Okay, good morning. My name is David Buster. I'm with SCORE Bucks County. Welcome to our webinar on preparing for the new norm as you reopen your business. This webinar is sponsored by SCORE and in cooperation with the law offices of Christina Reger, who you see her on your screen. Just a few quick notes about SCORE, Bucks County. We are an all-volunteer national nonprofit. Our mission is quite simple. We foster the growth of small businesses. And not only small businesses, but entrepreneurs as they look to start a business. We have 50 plus all volunteer members in Bucks County. And we reach our mission by offering seminars, workshops, and webinars on all aspects of business, from starting a business to selling your business. In addition, we provide free, confidential, face-to-face mentoring with one of our experienced volunteers. You can have as many sessions as you want. If you're starting a business or you have a business and you're facing challenges, you want to grow your business, you want to understand certain aspects of your business a little bit better, you can arrange to sit down as many times as you need with one of our volunteers. To schedule a mentor, to attend a seminar, even to volunteer to join SCORE, we welcome volunteers all the time. Visit our website at Bucks County SCORE, buckscounty.score.org. One or two little housekeeping notes. The entire session is being recorded. Once the video is processed, each of you will receive a link to the video. So if you don't have to necessarily scramble to write things down, you can go and rewatch the video as many times as you feel necessary. At the bottom of your screen, you see a Q&A button. During the presentation, as you have questions, just jot them down in the Q&A box, and we will get to as many questions as we can before the end of the session. Well, you didn't come to listen to me, and I've bored you enough. Let's introduce Christina Reger. Christina is an attorney. She's won numerous awards. She's received many, many honors, being named to who's who of lawyers and who's who of young lawyers and all sorts of other accolades. She formerly was with a very large was a partner in a very large Philadelphia firm, but for the past year or so has been on her own. She specializes in employment law from the employer's point of view. I've known Christina for a number of years, and I found her not only to be a very, very competent attorney, but a very, very nice person. So without further ado, Tina, it's yours.
Thank you, Dave, and thank you for the great introduction. Let me just share my screen now. Can everybody see that? Dave, can you guys see that? Let me see. I'm looking for the chat. So I encourage that you ask questions throughout. I am prepared to answer as many questions as I can throughout the presentation. So certainly please ask your question. It's always easier, I think, to ask the question on the topic that we're on than to come back at the end. So I will try to keep my eyes on the chat box as well as the presentation screen to get to as many questions. I've also left plenty of time at the end to make sure that all of your questions are answered. These are really challenging topics and there's a lot of them to juggle at the same time. So I want to make sure that I can help in any way that I can. So just a little bit more about, let me see. Okay. So as Dave said, I was a partner at a law firm in Philadelphia for many years. About last year, I decided to go out on my own to open the law offices of Christina Reger, specializing in employment law, primarily on the side of employers, but I do work with individuals on severance agreements and other negotiating contracts for employment agreements and those types of things. But primarily, I work with employers. I do some litigation. I did litigation for 15 years, but I try to focus my practice on compliance work, really trying to make sure that businesses do what they need to do in advance to avoid that lawsuit, whether it's how they let someone go, how they hire someone, how they implement all of these regulations, what policies they have in place, and just make sure that they have all the tools that they need so that they don't run into litigation problems. Just a couple disclaimers, as lawyers love to give. I'm not giving legal advice. I try to give very general advice, and nothing that we talk about here today it will all be hypothetical. So I'm happy to answer all of your hypothetical questions. That nothing that I say here today creates an attorney-client relationship. If you'd like to do that, I have all of my contact information. I've, in anticipation of it, as a result of COVID, I've put together lots of flat fee discounted packages, like half-hour consultations and things, just to help business owners kind of get through this process and discuss their individual problems and questions. So what we're here to talk about today is really this balancing act. The governor has announced that as of June 5th, he anticipates moving the rest of the counties that are in red to yellow. And what does that look like? And we'll talk about those 3 different phases. But to do that, there's a number of kind of balls in the air that employers really, really need to focus on. And they need to implement them at the same time. So the first thing is the governmental orders, whether they're the CDC and the OSHA orders from the federal government, or the orders from Governor Wolf, or the Dr. Levine's orders regarding social distancing and safe practices for employers. Or the city of Philadelphia has its own orders. So if you're practicing in the city of Philadelphia, there's additional orders that you need to comply with. And then you need to balance that against the PPP program and the PPP loans that many of you have through the CARES Act, and your requirement or need to bring these employees back as soon as possible to meet those thresholds to get that forgiveness. And you have to balance that against the unemployment that people are receiving, that in many cases is more than they would get if they're coming back to work for you. So how do you handle that? And then lastly, the last piece is there are going to be people that are going to qualify for the Family First Coronavirus Act. When this all first started in late March, I know I did a whole seminar on that, but we'll cover it very just generally for those of you that weren't able to attend that or didn't have really a need to get up to speed on that regulation because your business was shut down. And now that it's reopening, you have a need or a desire or a require to kind of put that in the mix as well. And what does that look like? So as I mentioned, there's 2 key federal orders that you need to be well aware of. There's the CDC, which has put out a number of orders regarding safety and social distancing. And then there's also OSHA, which has put out a lot of orders. And there's a recent guidance that just came out earlier this week regarding employers' requirements to do this contact tracing if they have an employee that tests positive for COVID. So those are on the OSHA website. And there's also another key player in all of this that I didn't put on here because they're not really putting out orders on safety like the other 2 organizations are, and that's the Department of Labor, which OSHA is a part of the Department of Labor, but the Department of Labor is the organization that is overseeing the Family First Coronavirus Act #1, and to the extent that you've moved people from exempt to non-exempt status because of an hour switch or a job switch or reorganizations, which many small businesses are going through as they're eliminating jobs, you need to make sure that you're complying with all the regulations through the Department of Labor. And then you have the state orders, which, as I mentioned, there's a number of orders that the governor has put out. There's a number of orders for specific business lines. Like, for example, I know there's been construction orders and guidance that has been issued by the state. And most recently, there's been restaurant guidance that has been issued by the state, as well as just general operating guidelines. And we'll talk about some of those in the presentation today, as well as Dr. Levine's orders, which have been incorporated by and adopted by Governor Wolf. Sorry, I do a lot in Jersey too. So I have Governor Murphy and Governor Wolf. And then the city of Philadelphia, not to be left out of the loop, has also issued some orders, particularly and most predominantly in the area of construction. And I believe they might have one in the restaurant industry as well, but predominantly in the area of construction as businesses begin to open up. So I'm sure most of you have probably seen or heard or are familiar with the governor's order regarding the open up process for the state of Pennsylvania. And what that looks like is a green, yellow, red system. Nobody in the state of Pennsylvania is in green yet. Many states are in yellow, many counties are in yellow. And then there's a handful of counties in the Philadelphia region, Chester, Bucks, Montgomery, Delaware, and Philadelphia counties that are still in the red, that are expected to move to yellow on June 5th. And I know that while last week that might have seemed very attainable, this week, particularly for businesses closer to the city, that might seem like a stretch right now with all of the civil unrest going on. And those are factors that, while I don't have slides on those, I'm happy to kind of talk through those, because I think that adds a whole nother layer of what employers need to consider in terms of the safety of their employees. And particularly the OSHA requirements that require all businesses and all employers to do things to keep their employees safe. So, and I have it on good advice, you've heard it here first, that the state is expected to move to green on June 19th. So you've heard it here first, really close connections with the governor that I've heard this information from. So, but what that means is, and the concern that I have from a legal perspective is, what if that doesn't work out so well? And then businesses have to move back into yellow. Are you as a business owner not only ready to reopen to yellow and then potentially green, but what if that gets pulled back and you have to go back into yellow or even red? So you need to not only prepare to reopen, but prepare to scale back again as well, because I don't think that this is the end. And I think that this is going to be part of the process that employers are going to not only have to prepare for, but go through in the next year or so. The governor's orders require two very important things, and the city order, if you're in the areas of construction, require the same thing, but for each job, is a safety plan, or what I call a COVID policy or plan, which is, this is what you're going to do. This is how you're going to temperature check or check employees every day. This is how you're cleaning the office. This is how you're maintaining social distancing. This is the masks that you're going to use. You're going to supply them. You're not going to supply them. This is what you're going to do with the kitchen. This is what you're going to do in the conference rooms. How are you keeping your people safe? And then on top of that, if you're in a business that is, for example, in a high rise or in the city or in a big office complex, what does that look like? And by that, I mean, how are people getting in the elevator? How are people getting into your office? What if you have shared bathrooms with other offices on the floor? How do you keep your people safe in those circumstances? If you're bringing people back all day, what are you doing with lunch? How are you keeping people in the kitchen or out of the kitchen? How are you maintaining the flow in and out of those common areas? Copy rooms. How are you using the copy rooms? How are you maintaining the cleanliness between usages of people? Same thing with microwaves, coffee makers, Keurigs. all of those high touch areas, what are you doing to make sure that those areas remain clean, and not at the end of the day or at the end of the week, but after each use? So those are part of what goes into a safety plan. The other thing that employers need to consider is, if you're doing temperature testing and you're bringing people back, what does that look like? Are you going to have a line of people at the door? They have to be 6 feet apart. And you have to balance that against, if you have someone in the front of the line that comes up with 101 temperature, are you sending them home right there? Is everybody in the line privy to that now? Now you've violated that individual's health information and confidentiality. So how are you maintaining that information without compromising that person's confidentiality if somebody does indeed come in with 100.5 or 100.8 temperature? So we can talk about solutions to that, and throughout the presentation I'm going to talk about a toolkit that my office has put together for employers. And we have all of these policies, they're ready to go, they're all in Word, and they're customizable to your business. So the other thing that you need to look at is, if you have visitors, if you get a lot of deliveries, what does that look like? Do you have a lot of people come through? Do you do a lot of meetings where people need to sit in your conference rooms that you're no longer doing? Like, what does that look like? If you're like one of the offices here in Bucks County that I'm aware of, they do that new, the new IDs for the driver's licenses. So people actually have to come in. So you have strangers coming in all the time. What does that look like? So you have to think through every process that you go through as a business, and you need to put that in your plan and make sure that your people are safe, those that are in the office or those that are in your business location. The other thing that the governor is requiring is that every business have a pandemic safety officer. And there hasn't been there's not a job description per se for that, but that is the individual that has been named by the company to administer the policies, respond to questions and concerns from employees, and respond to requests for sick leave or FFCRA, what we call FFCRA leave. You know, how does that work? And to the extent that you're a small business and you don't have this person, or you don't have the resources to have this person, my office has partnered with a company that is providing this service, this pandemic safety officer, at a minimal cost to smaller businesses. So if that's something you're interested in, you can email me about that as well. It's just about getting all of the information and resources out to all of you so that you can implement these policies in a way that works for your business. So let's move on. Oh, and one other point about the pandemic safety officer, the city of Philadelphia, and I mentioned this quickly before, in the construction industry, has said that you need a pandemic safety officer for every job. So every job that company is on, they need one of these officers on that job. So, or designated for that job. So a little bit more of a rigorous standard. Okay, so as I mentioned, this is the phased reopening, red, yellow, green. This slide is just more informational. When you get the actual PDF of the slides, the link is there. So if you want to read more about each of these, and I have some information on the coming slides, but if you want to read more about the actual order and how everything was set up by Governor Wolf, you can go to that link. If I have a 2-person barbershop, do I really need a pandemic safety officer? And what happens if I don't? You really need one. There's no limitation on size that I've seen in any of the regulations, but for all intents purposes, what I say to that is, you, the owner, be the pandemic safety officer, and either have an HR consultant or an employment attorney like me, that I work with all small businesses on speed dial. Like, hey, I have this issue. This is what my person said. What do I do? It's as simple as that. I mean, you don't have to have something where you have somebody that's providing an answer instantaneous. It could be as simple as, let me look into that and I'll get back to you. Okay. So this is where we are now, that we are in the red phase in one of the 5 county areas that are still in the red phase. And we're not the only, there's definitely some near Pittsburgh and Harrisburg. I think there's still 20 counties in the red area or so. But only life-sustaining businesses, limitations on congregating, schools and most child care providers and child care establishments are closed, and most facilities are closed to the public. Stay-at-home orders are in place, and larger gatherings are prohibited. Restaurants and bars are limited to carry out and delivery only. And sadly, in the city of Philadelphia, most of them have boarded up. And only travel for life-sustaining purposes. Where we will be as of Friday is in this yellow phase. What that really means is if you're a business that's been operating and continues to operate by telecommuting, you should continue to consider that and do that whenever possible. Businesses with in-person operations must follow all of those safety orders, the social distancing, the masks, the PPE, the cleaning. A lot of companies are putting up those plastic barriers. So we're seeing a lot of that. I mean, there's significant costs that go into some of this. And there are still limitations to things like spas and gyms. I believe that casinos and all indoor entertainment, and I believe barbershops and hair facilities might still be in this prohibited in the yellow phase. At least that's what I've seen in other readings. And that gatherings are limited to 25 or less. But there is more of a push. Now that being said, I was out on Sunday. It was a beautiful day, and we drove through Peddler's Village, and it was mobbed. There was people everywhere. Most of the stores were closed, but even the stores that were open, like the carry-out pizza place and ice cream shops and things like that, there was mobs of people standing in line. So it remains to be seen kind of where this goes, but this is where we should be as of June 5th. And then as of June 19th, most or all businesses can remain open or can reopen. And they must follow the PA Department of Health, which is Dr. Levine's orders, and the CDC orders. This will be monitored to the extent that if the numbers start to come back up, I think you will see businesses start to go back into the yellow. I do see camps starting to open up. I think it's the big question is how are people going to react? Are they going to go out to dinner? Are they going to put their kids in camp? Or are they too afraid? And then what happens if it goes back to yellow? What does that camp owner do? But also, what do those people do with their child that they now have anticipated would be in camp? So it's definitely challenging in terms of not only thinking about reopening, but thinking about the possibility of going backwards again. The other thing that it's really critical to think about is the exposure from the perspective of this concept of masks and wearing masks. And Dr. Levine's orders, as well as the CDC orders, talk about what people should wear masks, but it's not a must. And what I am seeing, when I do go out and about, is these signs on storefronts that say you must have a mask to enter. That is not the law. And there's already a case in the western part of Pennsylvania in federal court that was filed last week from a woman who was attempting to go into a grocery store, and there was a sign posted that said, you must have a mask to enter, and she was denied entry. And when she said to the store, not the owners, but the people that were at the doors, that she had a respiratory condition and she could not wear a mask, they prohibited her from entering. They said they would pick up whatever she needed and bring it to her, which I think is a decent accommodation, except people in the store that were employees that had conditions were allowed to go without masks. So there's an inconsistency there. And I think that that's part of what's going to cause a problem for this store. but the store was so adamant that they were calling the police if people resisted their regulation. And the lawsuit is claiming an ADA disability discrimination claim. So I caution you, as you're reopening, particularly if you have a store that is open to the public, the mask regulation is not a must. Particularly if someone says to you that they have an ADA or some type of disability that prohibits them from wearing a mask. So consider that in terms of who comes into your storefront, what type of people you're interacting with, and from the perspective of employees and those patrons that you have coming into your store. While you certainly do have an obligation under OSHA to keep your employees safe, you need to balance that. This is all about balancing with violating a discrimination or federal regulation. So, okay. This again is another slide that I think is just more helpful to have for all of you when you get the actual presentation. This was put together through the state of Pennsylvania and provides a directory of where businesses can get these supplies. Now, you had to register to be on this registry. It's pretty extensive from the last time that I looked at it, but I'm sure that supplies will run in short, and people will be out of supplies. So, you know, even if you're thinking of not opening until July or August, like these things are going to be on back order. There's going to be delays in getting them. So to the extent that that you need these supplies, this is a resource on where you can get some of them. What about outdoor team sports? Are practices and games acceptable once they're in the yellow phase? I don't know. I would say yes, to the extent that I would analogize that to a camp where you have this interaction between people, although I haven't seen anything specifically about outdoor sports. But I have also seen that gyms and places, these high touch places where there's sweat and things, they're still prohibited in the yellow phase. So if I can get a better answer on that, I will certainly send that over to Dave to get out to all of you. I haven't seen anything specific about it. What stops everyone from just saying they can't wear a mask when in reality it was just that they don't want to? That's a great question. And my answer to that is there's always going to be that guy or that girl, that person that's going to just be obtuse and obnoxious and not want to wear a mask. And I think that if somebody says, I'm not, if you have that type of policy and you approach someone and you say, it's our policy that you wear a mask in our store, and they say, I don't want to, or I'm not wearing a mask, that's an entirely different response than somebody who says to you, I can't wear a mask, I have this medical condition. And I really think that that's really truly where the distinction is, because if that obtuse person then files a lawsuit, your answer as the business owner is, they never mentioned to me that yes, I'm a place of public accommodation, but they never mentioned to me that they had any kind of disability that prohibited them or barred them from wearing a mask. So, you know, I think that people that can't wear a mask for those reasons are going to be forefront about it and say, look, I have anxiety attacks, I have panic attacks, I can't wear a mask. You're still going to get those people that are going to lie. Absolutely, absolutely. And to the extent that you can say, you know, we try, it's our policy that you wear a mask, is there something that we can get for you and bring it to you? You know, if there's ways that you can work with them, there's certainly those options available. But I think that that's really your remedy, is just to listen to what the response is that you get from people. Sorry, I have to tell my kid to stop making noise. Beads and masks. Can I require, I think that's beards. Beards and masks. Can I require cutting or trimming of the beard? That's a really interesting question and not one that I've seen. I would say that You can. I have many companies that have policies on facial hair. I would say you're probably in a safer position if you first update your policy, your general handbook policies on beards and facial hair, or hair in general. There's been a number of cases, particularly in New Jersey, about hair in certain hairstyles that by limiting or prohibiting them, it could be discriminatory, but that deals more with the African American population and the cornrows and the different hairstyles. But the beards, I would start with a policy just generally about that. And then I think that you can have that discussion with your employee. What I caution you against on that situation is you might get a response that says it's a religious. I don't cut my beard for religious reasons. So you need to be prepared for that type of answer before you do that. So let's keep going. I just want to make sure I don't have anything in the chat because I actually see two places where people are posting questions. Okay, let's go back. Okay, so couple more things on complying with federal, state, and local orders. Obviously, the social distancing. The other point that I want to make on that social distancing piece is that to the extent that you are in a building that has common areas, or you're leasing space in a building that has an elevator, or like a building in a city that's really has a ton of people, check your contract with the building manager and see what their obligations are and what yours are, because they might have obligations as well. But also just generally, it's a good recommendation to just work with them, see what they're doing, see what you're doing, see, particularly in places that have like a common bathroom on the hall, and there's a number of businesses that feed into that bathroom. I would say that that's the building's obligation and what are they doing? But also, notwithstanding what they're doing, what are you doing to keep your employees safe in those circumstances? So that's a big kind of pitfall in terms of the social distancing that we're working with a number of clients. Telecommuting, as we move into yellow, and a lot of companies are not only keeping their people telecommuting, but looking at the bigger picture and the longer range plans in terms of, office space is expensive to the extent that you have people that now you can move to a home location more permanently, that want to do that, particularly if they want to do that. You should be putting telecommuting policies in place. And in that toolkit that I've been mentioning, we have a telecommuting policy to the extent that you're moving into different phases and you're continuing to keep people at home. You should definitely have these people sign a telecommuting policy. You also should be considering buying them company-owned laptops, company-owned equipment to the extent that they're using their own. You also need to consider safety risks, cybersecurity risks. I can tell you that I had a case just earlier this week. My client is a accounting firm that does bookkeeping and accounting, and they received an email from their client saying to put these 3 people and pay them through the payroll PPP funds, and sent over signed W-9s for these people. And the bookkeeping company and accounting company did that. And the payroll was processed for 2 payroll periods before the owner realized that they were fraudulent. And my client did back checks on her side of the cyber technology wall, and everything was legit. So the hack that came through was on the side of her client, the actual person that had the PPP funds, but there was to the tune of about $50,000 in fraudulent payments to these 3 workers as a result of these this hack. So when you're thinking about telecommuting, all of those security issues that you have in place for people at your office, you need to put in place at home. The other thing I need to caution you about is if you're continuing to put people on telecommuting, two things. One, I think employers are very quickly losing that right to say, we have all our people in the office, we don't telecommute, particularly if you've been doing it all along. That FaceTime everybody in the office, position is quickly eroding with employers who allowed or made everybody work at home to keep their business operational over the past 2 months. It's a very difficult decision now and argument to make to say we don't allow telecommuting. So thinking about that. But lastly, on the telecommuting issue is workers' comp. If you have people that are now working at home and will continue to work at home, please, please, please call your workers' comp carrier. Talk to them about this. Talk to them about other insurance. What else do you need? Because if these people get hurt while they're on your hour working at home and they make a claim, you want to make sure that you're covered. So really think about that. And lastly, I think I already mentioned the employee screening, the confidentiality issues that go along with taking temperatures and what do you do and how do you manage that. The toolkit that I have has like a self-assessment that each employee fills out every day, and it's a weekly sheet, and then they hand it in at the end of the week, and then the employer keeps those in a confidential medical file with the other medical records. So that's how we're addressing it with a large majority of our employers. And then as well, if you have an employee that goes on vacation or is out for a few days, there's a different form if they've been out of the office for more than 3 weeks about having them come back and filling out that form. So I see a couple more questions in the chat. Is it mandatory to take employees' and clients' temperatures? No, it is not mandatory. It is now permissible. Obviously, those things before COVID were never, ever permissible. That was all confidential. But in the state of a pandemic, those things are now permitted by the EEOC and the Department of Labor and the CDC. And so that's permitted but not required. If spas where services are closed, can we refuse service if someone cannot wear a mask? If spas where services are closed, can we refuse service if someone can? You can refuse service. I haven't seen, but I think that you're walking that fine line. I think if it's a spa and you're refusing service to a customer because they can't wear a mask, I think that, having at least that initial discussion with them, I don't think you want to bait them to say, I have a disability, but to say it's really our policy. And if they say, I don't want to wear a mask versus I can't wear a mask, why can't you wear a mask? I mean, I think you're permitted as the business owner to ask that additional question because you have that OSHA obligation to keep your employees safe. And I think in a spa or a hair salon type of situation where you have that close contact between the provider of the service and the customer, I certainly think it would be okay to ask those questions and then take it from there. But those are certainly questions to protect both your employees and that customer. What if federal, state, or local regs are in conflict? Which take precedent? That's a good question. Typically, the state regs take precedent over the federal regs because the state regs are more stringent. So I would say to the extent that they are in conflict, it is the one that is the more stringent rule that typically applies. Next question. Hold on one second. Walmart clearly posts that you cannot enter without a mask. That is state law. Saw it last night. I know. I've seen it as well on a variety of different locations. And I just want to go in and be that person again. That's like, you can't do that. But yeah, that lawsuit is pending right now in the Western District of Pennsylvania in federal court. So, I mean, again, it's one of those, now you see why lawyers say it depends. It's one of those situations where you know, it depends. That woman could lose that lawsuit, but it's pending. And do you want to be that business owner that gets that lawsuit? So I caution you, when I read it, I was like, wow, I didn't know that either. And I caution you as a business owner to just be aware of that situation. Can businesses say it's state law? It's not state law. If you look at the state regulations, they do not say must. So read them again very carefully. They do not say that they must wear masks. They say it is recommended. And that's what this case is citing in its initial complaint, which the complaint was just filed last week. So we will see. It will be to be determined, but I think and I just raise it as you need to be aware of this situation, and have that employment lawyer on speed dial and say, here's the situation we have. So I think that a lot of this is just cautioning you, educating you, and letting you think about who your population is and who's entering your doors. Okay. Let me just make sure I'm trying to answer all the questions as we keep going. What about what about the old message, no shoes, no shirt, no service? You could say no shoes, no shirt, no mask, no service. I think that's great. All right, let's keep going. Okay, so as you're developing this action plan, the safety plan, this COVID plan, the other thing you need to consider is, what are your staff considerations? Who's staying home? Who's returning to work? Who are you paying on the PPP loan that is not returning to work, that you're paying to stay at home? What's that person's response going to be if you're bringing one person back and you're not bringing the other one back, and they have the same job and you're only bringing one back and the other one's getting paid to stay at home because you have these PPP funds to use? These are all things you need to consider. But on top of considering the who, consider the why you're picking the who. And be very careful about not picking people in a discriminatory fashion. I say in every presentation that I give, and I've given so very many over the past 10 weeks, is the pregnant lady. I always have the pregnant lady, and employers go nuts about the pregnant lady. And I tell you that because in presentations that I've done prior to COVID, I always talk about pregnancy discrimination and how juries love pregnant ladies. But what do you do with the pregnant lady? You know, what I say to employers is, have a conversation. Don't assume, because then you have a perceived disability issue. If that pregnant lady wants to come back and work, they have a right to come back and work and earn money. If they say, nope, don't want to come back, my doctor's saying I can't come back, I'm going to get a doctor's note, then you have a different set of circumstances to deal with. But all of the regulations that have come out over the past 10 weeks have talked about employers being flexible and open with their employees and having open and candid discussions with their employees about the situations. And so I really caution all of you to have those conversations with your employees about their situations, or your perception of their situation. Okay, so the other thing is timing of return. So I know that many businesses that I work with that are in the manufacturing industry they're open longer hours, and they're putting in 2 shifts of people. I have other clients that are, have selected a shift A and a shift B. And so shift A works 1 week, and only shift A comes in that week, and shift B works at home. And then shift B comes in week 2. And that way, if somebody in shift A gets COVID, you have a secondary shift backup that can come in and work all the hours. So those are just considerations that I throw out there in terms of, as you're thinking about bringing people back, or leaving them home and making them work, continue to telework. The risk assessment, I think we kind of already covered in terms of, what does it look like? What is the exposures in your office place, and the screening protocols as well for for taking temperatures and assessing employees and their, how, how they feel and if they're showing any of the symptoms. Let's see. Are there support tools, unemployment, etc., for those who medically can not come back to work or are pregnant and the doctor says they cannot go back to work? Yes, we will touch on those. So there's a lot of different kind of angles and things that employers need, like all these balls that are juggling in the air. So we're going to address that. And to the extent that we don't, I'll see if I can kind of pull it back in at the end and summarize it once we've gone through all of this. What happens if one staff member has COVID? Well, I would direct you first, if you have a staff member that has COVID, I would direct you first to make sure that you have your policies in place, which is the next slide. Make sure you have your sick leave policies. If you're in the city and you have Philly sick leave law to deal with, make sure you have those policies in place. If you're a business over 50 and you're dealing with FMLA, make sure you have FMLA in place. And your COVID policy, your pandemic or safety policy should also touch on what happens if you have an employee that is sick. First, the new CDC regulations or guidance requires, I think it's OSHA guidance requires that employers begin to do this contact tracing. And in my toolkit, I have a contact trace form. We also have a form that the first thing the employer needs to do is try to determine where that person got COVID, when they got COVID, when they tested positive for COVID. In terms of what's available to them, they automatically qualify for 2 weeks paid sick leave under the FFCRA, which we'll talk about a little further down in the presentation. But then it becomes the process of letting the employees know that we're exposed to that person. And I have a form in my toolkit for that as well, and a process that an employer needs to go through, including a checklist of notifying other employees. But you have to do that cautiously because you cannot disclose who the person is. Now, obviously, in most of the businesses that are probably on this call and most of the businesses that are my clients, if Mary Sue stops showing up to work for 2 weeks, it's pretty clear that Mary Sue is the one that has COVID, but it shouldn't come from the employer, and the employer shouldn't be the one to confirm that it's Mary Sue. The answer is one of our employees has tested positive for COVID, and I encourage you to get tested, watch your symptoms, or quarantine, depending on the circumstances of that exposure. So let's see, let's keep going. If an employee declines to return to work because of the underlying health condition, do they lose employment? If the employee declines to come to work because of the underlying health condition, that depends on the circumstance. Generally, I will say that they would probably be entitled to 2 weeks. What I've been working on with my clients, again, taking this flexibility approach, is the first question I ask is, what does your policy say in terms of paid sick leave, paid time off, vacation time? Is it accrued? Have they used it? Do they have it available to them? Can they use it? They also may be entitled to the FFCRA for 2 weeks of paid sick leave if they have an underlying condition in a doctor's note that says they shouldn't return, to the extent they haven't used that already. If they're an employee that you would like to try to keep on, you can furlough them and continue to maintain their health insurance, and we'll talk about this down the road, or you can lay them off. There's no obligation under the employer to keep someone in a job because they are afraid to return to work or have an underlying medical condition that they don't want to return to work, which ultimately is because they're afraid because of the underlying medical condition. So there is no obligation, but in those circumstances, I would say talk to an attorney, make sure you dot all your I's and cross your T's. In many of those circumstances that I've been working with employees, we've been doing severance agreements to give that employee a little bit of a soft landing and to insulate that employer from a potential lawsuit. So those are things that I would highly recommend that you consider. So I think we've done a good job of covering all this. These are some of the key policies that employers should consider having in place before they open, and you really need to kind of balance them against the OSHA and CDC requirements, which we've already kind of beaten a dead horse with, as well as those insurance requirements, particularly the workers' comp. Other states have done a great job, and I think Pennsylvania has done a great job in the healthcare insurance industry, that the healthcare insurers have done a great job of saying, this is what we're doing, this is what we're covering, this is what we're not covering, we'll allow furloughs. And the workers' comp in Pennsylvania, I have seen nothing as a standard announcement of how they're covering, what they're covering. From a legal perspective, I would tell you that I can't imagine that a workers' comp would cover COVID, because it's so difficult to trace back where the person got COVID. But that being said, with the new contact tracing forms and training, there's certainly this kind of feeling of holding someone accountable. Somebody has to pay if my worker gets COVID, and whether that's their job, or I don't know how you can just determine whether somebody got it at the job or the liquor store or the 7-Eleven, but that remains to be seen, and still a fight. And so certainly still a legal battle. So I just tell you, please pick up the phone and call your workers' comp carrier and have that discussion with them. Let's keep going. I'm going to run out of time, and I thought I'd have plenty of time. Balance staff with children at home. I will talk about that. Can we request they return in shifts? Yes, that is certainly something that I'm doing with, like I said, my manufacturing people. And even up until last week, I have a client in the city that was getting ready to open up, and they were saying, they were staggering their employees that were coming into the office every 15 minutes. So, so that's certainly something that you can do. Let's see. Let's talk a little bit about the Paycheck Protection Act, which was part of the CARES Act. I don't go a whole lot into this because I leave this to my accounting strategic partners like Mike Davis's CPA firm and other accounting practices in the Bucks County area that know this inside and out. So to the extent that you have PPP questions, talk to your accountant about making sure that you're complying with the requirements and restrictions to get that forgiveness. But I, from a legal perspective, tell you that the PPP program was intended as a revenue replacement for small businesses, and to help small businesses pay their operating expense and pay an incentive to keep employees on the payroll. What it was initially touted as, I think, for many small businesses was, you got to apply for this, it's free money. It's not free money. There's some very strict guidelines in terms of what percentages. Right now it's 75% for payroll and 25% for operating expenses, but only certain operating expenses and only certain taxes and payroll expenses that get rolled into what constitutes that 75% and 25%. And to make it even just more challenging, there's a number of bills that are pending to extend this 8-week pay period, this measuring period of which you're supposed to use the money in 8 weeks, to 24 weeks and 12 weeks. I've seen a number of different proposals. So this slide just kind of gives you a very 10,000 foot overview on what the PPP requirements are. I tell you to work with your accountant and make sure that you are documenting and keeping track of how you're spending that money. I know what I've recommended clients do is put it in a separate bank account and just pull out the expenses that you need. It makes it so much easier to trace that way. But these are generally, as of today, the requirements as they stand. There's been some guidance that's been issued in the past couple weeks that kind of further define this and the measuring period, but nothing has changed. That's 75%. and nothing has changed that 8 weeks. Okay. So about 2-3 weeks ago, the SBA came out with the forgiveness guidelines. It's about a 10-page document. And so I copy this for there. I'm not going to go through all of this, but this is the criteria upon which the SBA has said they will forgive those loans. And I'll leave that kind of for you to review at your leisure, but I put it on there just so you're informed, and you can check out the SBA website for more information regarding, you know, what the specifics are and what that application looks like. Okay, the unemployment dilemma. So this is a challenge. Because when COVID first happened, to the extent that companies couldn't, or even if they could, you know, require or allow some of their people to telework, they couldn't do that for everyone. So employers laid off, and many of them furloughed. And furloughed was not a term that I think was generally used a whole lot before COVID. So it was a big kind of, what's the difference? So I can tell you that the difference and the distinction really is a layoff is a sever. It means that that employee is no longer on your rolls. They get their COBRA letters, and they have the ability to collect unemployment. The difference between that and furlough is that a furlough, from a legal perspective, is that employee is still listed on your rolls as an employee of the company. They still get health insurance as an employee of the company. They don't get a COBRA letter. They don't get a COBRA letter that says that they can continue on the COBRA policy. They're still listed as an employee. So what we're seeing is two things. One is that employers now have their PPP funds, so there's this giant push to get their people back and pay them. And I think it becomes, for many entrepreneurs and small businesses, it's completely against everything that they believe in to pay people to sit at home. But that's what you have to do. That's the purpose of the PPP, was to get people off unemployment. And so to the extent that you are paying people through PPP funds, you're taking them off unemployment and paying them through that funds, even if it means you're still keeping them at home. What you can do, and what I have seen businesses do, is now's the time to train them. Sexual harassment training, other core training, if they need Excel training or PowerPoint training, or train them. You have to pay them for that time anyway. And if they're sitting at home, make them go through those trainings or certifications or CPR or whatever other things, notary, whatever other things that could be useful to your business, pay them to do that. The other thing I've seen is employers are saying, you know, God, I always wanted to like kind of paint, have them paint your store, have them go through your inventory, have them do your liquor counts for your, clean out the liquor cabinets in the restaurant, like all cleaning, all of that stuff. Like, that is things that if you are paying these people, you can bring them in to do that, even if you can't actually physically open your location to the public. These are things and solutions that we're recommending employers do, rather than, or as an alternative to, employees sitting at home. The other thing is, if you are bringing them back and you laid them off, they are now a new employee. So what that means is, keep in mind that you need to do all of the things that you would do for a new employee. So if their I-9 is more than 3 years out of date, you need a new I-9. You need to register them as a new I-9. You need new paperwork on them. They are laid off. So for all intents and purposes, you're hiring them back. They're hired back as a new employee because they weren't furloughed. So, so keep that in mind. And lastly, the big kind of problem or concern that comes into place with this is that we're dealing with employers on is, I don't want to come back. I'm making more on unemployment now than I ever was making working, so I don't want to come back. And to that, the response is, you are no longer eligible for unemployment if there's a job for you to come back to. So to the extent that there is an available job, if Joe was working full-time for you and you're calling Joe back and saying, I have full-time work for you, and Joe says, I don't want to come back, I'm making more on unemployment, then, you know, the response to that is, we're recommending that employers don't say, well, you're no longer eligible for unemployment. The response is, well, your refusal to come back may impact your unemployment. Now, couple pieces to put into play here in this whole balancing scheme. We're recommending that employers document in writing, send a letter in writing to the employee asking them to come back. If they refuse, document that. If you're working with younger populations that text more than they write or email, document it. Print that text. The reason is those individuals who are refusing to come back. So part of that PPP loan is that you have to maintain your employee counts by certain measuring periods, and those have changed a little bit with the new guidance and the new regulations that have come out over the past month. So I would say work with your accountant on what those numbers are. But if somebody is refusing to come back, that person comes out of those counts, and so you're not required to fill that position. They just come out of the numbers, but you may need to prove that. And there hasn't been a whole lot that I've seen on, you know, what you're going to be required to prove that forgiveness. And so we're saying is provide or prepare those documents now, just like with the FFCRA, which we'll go to next. Prepare those documents now in the event that you need to prove them for either your forgiveness or your tax credits. In the toolkit that we have a whole recall procedure. We have a template letter to send to employees, and we also have an internal document to document, you know, what this employee did, their name, what they did, how many hours they worked, when they were laid off or furloughed, when you called them back, what kind of hours you promised them to come back, was it the same, and what their response was, in addition to that letter that goes out to them. So you need to keep that for your PPP to the extent that they don't want to come back. The last piece of this is, if they don't want to come back, then there's a new form that the Unemployment Compensation Office, which is also in the toolkit, the link to the form, it's called refusal to return to work, I think is the exact title. But it's a form that the Unemployment Compensation Office in Pennsylvania has created that employers would then fill out. You can print it and submit it directly online, and it goes to the unemployment office, and then hopefully will impact their ability to collect unemployment. And then you might be getting calls saying, I'm ready to come back to work, if their unemployment is cut. So, and I know some employers are saying, well, that seems so harsh, I feel so bad. You know, the reality is we got to get this economy going again. And if you're offering them a job and they're not working, you know, I'd love to sit at home all summer and collect a paycheck too and not do any work, but it's not how this works. And unemployment, when COVID hit, unemployment removed the requirement that employees need to be looking for a job, which was the standard kind of before COVID. But there still is that requirement that if a job is offered to them, then they can't refuse that job, particularly at their old employer. What if you are working less? Can they still collect unemployment, and to what amount? Typically, unemployment, although I think that formula, however they calculate that, is much like just sticking your hand in like a magician's hat. But it's typically 2/3 of their salary, up until, to certain limitations. Up until July 31st, they get an additional $600 a week. That when COVID hit, the part of the unemployment compensation changes were that employees were eligible to collect unemployment for a reduction in hours. So yes, if you are reducing their hours and number one, they're refusing to come back because the hours are reduced, you send the letter. If you're reducing their hours, they could still be eligible for unemployment. And the last documents I read, which was just a couple weeks ago on this, was that they were still entitled to the $600, and I didn't see that it was prorated, even if they got a reduction in hours and not the full boat, that they're completely entitled because they're laid off. So I can't tell you exactly what amount, but it's typically about 2/3. Now, I just talked to a client yesterday or the day before that said, we offered this employee to come back, and we don't have, she's in the medical profession that was closed. And so we don't have a full boat of patients for her to see. So she might see a patient for 2 hours and then have 2 hours off, and then see a patient for 2 hours. And this employee doesn't want to come back for that in that kind of choppy situation. But that's all the employer has. So if she's refusing to come back, again, it's considered a refusal to work, and that form should be submitted. So let's see, let me go to some of the questions, because I know that this is, Thank you, Dave, for saying that. I'm throwing pens at my child because he enjoys singing in the background on every webinar I do. So to the extent that you see my hand waving in the air, let's see. What if they're working less hours? Okay, the letter to the state unemployment office is also a requirement for the PPP loan forgiveness in order to exclude that person from the count. So thank you, Brian, for that. The letter, that document, I think it's form 1921. I learned that from Mike Davis's presentation earlier this week, the number, because lawyers are not number people. That's why we rely on accountants. 1921 is the form number. And you can get that form and then submit it. But there's also a print button. So print first and then submit. So that's where we are on the unemployment. So let's talk now. So you have the three pieces right now so far. You have the state and local orders, and the federal orders. You have the PPP, and then now you have the unemployment. And now the last piece is this Family First Coronavirus Act. It's essentially, in a very short nutshell, it's 2 weeks paid sick leave, and there's 6 qualifying reasons, and there's 10 weeks of extended family medical leave. There's an interplay with the FMLA to the extent that your business is big enough to qualify for FMLA, and that is that if you have an employee that has already taken a period of time for FMLA, they don't get another whole 10 weeks for EFMLA. It's 12 weeks FMLA, and the 12 weeks for under the FFCRA is 2 weeks paid, and then 2 weeks paid sick leave, and then 10 weeks extended family medical leave. There's exceptions for healthcare providers and small businesses, but the small business exceptions are pretty stringent, in my opinion. And this law right now sunsets December 31st. The time doesn't accrue. It doesn't have cash surrender value. It doesn't carry over to next year. And most importantly, the employee can't say, I want my time paid out if they're no longer with the company. It's only used for very specific circumstances. So here's the 6 qualifying reasons that you can get payments under the FFCRA. The first and overarching question for all 6 of these reasons is that the employee cannot work or telework. So if the employee cannot work or telework and your business is open, the first 3 reasons in the darker blue are what I call care for self. And those 3 reasons, you get your full salary up to $511 for 2 weeks. And with those 3 reasons, it's only 2 weeks. If their COVID lasts longer, if they have COVID and it lasts longer, what we are saying to employers is, what other kind of leave do you have for these people? Do you have sick leave? Do you have vacation leave that they can use? Do you have disability? Do you have an AFLAC policy? These are all the types of policies that we're working with employers to the extent that somebody has like their COVID lasts longer than the 2 weeks. The second set of reasons in the lighter blue on the right-hand side of the screen are what I call care for others. You're caring for somebody who's subject to number 1 or number 2 on the left. Reason number 5 is you're caring for a son or daughter, and that was pretty specific in the regs, whose child care or place of care has closed or school has closed, or is unavailable. And that has been extended to include camps, although I see camps opening up. Or the experiencing some kind of other similar situation or condition, which really hasn't been very well defined, notwithstanding being 10 weeks out. This regulation is monitored by the Department of Labor, so all of the same liquidated damages penalties apply. The monitoring started April 17th to the extent that there's violations to this policy. Number 5 in pink is the only reason that you would get the additional 10 weeks of the extended family medical is if you're caring for a son or daughter whose place of business has closed. So there was a question up in one of the chats about if they're balancing childcare issues. So this is where that comes into play. To answer that question about childcare, if they're teleworking and they're balancing childcare issues, much like me with my singing son, you have to offer them this leave. There's a Department of Labor poster that I have recommended to all of my clients to email out to all of their people, as well as post it in their workplace to the extent that they're open. But that is the leave that they would be entitled to. It's $200 a day, up to 200 times 5 days times 10 for the 10 weeks. It's all of the reasons on the right side. They're entitled to 2/3 of their pay, up to $200 a day. So that's how that works. But again, you get a dollar for dollar tax credit for this leave, for the FFCRA leave. So to the extent that you have employees that are requesting leave under the FFCRA, in my toolkit, I have a form for the employee to fill out, which requires them to put in all the information why they're requesting the leave. If they have a doctor's note, you would attach the doctor's note to the back of the leave form. There's also, I have FFCRA policy for paid sick leave and for extended family medical leave. I also have a poster that goes into detail about the exemptions if you're trying to get either the healthcare exemption or the small business exemption. And just super briefly about the small business exemption, the small business exemption under the FFCRA would require the business to show that they would pay out more in FFCRA paid leave than they would bring in revenue, or that it would jeopardize the business as a going concern is the overarching measuring standard or litmus that an employer would have to prove, that providing this leave to that employee or those sets of employees under, I forget now if it's 20 or 25 employees, but would jeopardize the business as a going concern. And in those circumstances, you can attempt to prove that you're exempt from providing this leave. But again, I think as more this slide shows, document, document, document. Whether you're taking the leave and you're providing them care under the FFCRA, have those documents. At this point, it has not been disclosed what you need to get those tax credits, but trying to get that in December when you're filing for your taxes, if you don't file quarterly, go ahead and try to do that with the year that everybody's had, to try to get that doctor's note or that proof that the school or child care provider was closed. Get it now, get the form filled out, get all the information from the employee that you need to get that tax credit. As I said, it's a dollar for dollar credit. If you file quarterly, you can offset it against any quarterly taxes you owe. So this is a wash for employers, except that they have to front the money. So when you have employees that are in these situations, whether they're too scared to come back, they have medical conditions, the pregnant lady who's going to have the baby in June, how do you do it? How do you cobble that leave together? And ultimately, to the extent that you still need a resource to actually do the work, what does that look like? This slide is also important because it's really, you don't want to lose sight of the fact that all of the normal requirements that an employer would have to abide by, like EEOC, ADA, Fair Labor Standards Act, they all still apply. If you're moving somebody from exempt status to non-exempt and now you're paying them hourly, that still applies. So keep those in mind as you're kind of reshuffling or reevaluating your business. To the extent that you have employees that are saying, I'm too afraid to come back, because we've seen that, you need to go through that same interactive process that you would have to go through for an ADA type of analysis. If it's just, I'm afraid to come back, or I live with Granny and she's old, there's none of what we discussed today applies to that. So then the question becomes, do you lay them off? Are they refusing to work? Keeping in mind your PPP numbers, but having that conversation with them and working through that with them is always going to be a better result than just saying, well, you're fired. And I think that most employers don't want to do that. They want to do right by their employees. But doing right by your employees and making sure you're complying with the laws are two very challenging and often competing sides of the same coin. So I know we're running close to the end of time, and I'm almost to the end of my presentation. So let me see if there are more questions in the boxes that I can answer. Are there support tools, unemployment, et cetera, for those who medically cannot come back to work or are pregnant or doctor says they can't come back? So that would be the FFCRA. So to the extent that they have a medical condition and they can't come back for that reason, I think in most circumstances they would get the 2 weeks paid sick leave under the FFCRA. If it goes beyond that, then you need to have those discussions with them. Can they telework? Are there other things that they can do? Can you shuffle responsibilities? As long as it's within the realm of reason, employers should try to accommodate that request to the extent that they can. But I think the other thing that as you're reopening and bringing people back that you're going to be challenged with is what does that employee who says, all right, you're going to call me back for 8 weeks and pay me, and then what? If you don't reopen, I have to go back on unemployment, and now I've missed that $600. So, and those are just conversations that you need to have with your CPA, your employment lawyer, to kind of work through that, and your employee. There's other ways that employers are kind of looking at those PPP numbers that I've seen in terms of hazard pay for those employees that are continuing to work. Those are certainly options. Bonuses for employees that are continuing to work. To the extent that you're working in a tipped environment, including in the amount of pay that you're paying people with the PPP money, the amount that they would receive in tipped money, or what they're reporting in tips on an average basis. I've seen that. So those are different ways that employers are kind of adjusting and working with those PPP monies. Let's see. So I have more questions. We are a small nonprofit and do not have a sick policy. Yes, everyone, the FFCRA applies to everyone. There are no exemptions on how they apply, except that you could qualify if you're a small business. you could qualify for the exemptions under the FFCRA. Can you set productivity expectations for those employees who can work remotely? Yes, you can. Just as if take COVID out of the picture entirely, if you would be setting that person up at home and you would be setting up productivity expectations, you can certainly do that. But I would, again, that in those circumstances, I would definitely have a telecommuting policy that they would sign off on that has that information in there. Oh gosh, this is a question I would, and maybe I think Mike Davis might be on this call if he's still on it. This isn't a question that I would refer you back to your accountant on, is if you received an EIDL grant, $1,000 per employee, and a PPP, is the EIDL grant amount subtracted from the PPP loan amount forgiveness and has to be paid back? I don't know the answer to that, but I can try to get you the answer, or to the extent that there's an accountant on this chat that can put that answer, it's in the Q&A. I would love to see the answer to that because I don't know the answer to that, but we'll get it to you, Donna. Let's see. I have lots more questions here in the chat. The letter to the state unemployment office is also a requirement for the PPP loan. We already did that. What if you don't have enough work for a worker to return? Well, that goes back to, if you're talking about PPP funds, then I know it goes against everything most of you believe in. You have to pay them to sit at home if you want to get that forgiveness. If you don't have that PPP piece in the mix, then you just don't call them back and they stay on unemployment. The extended FMLA, so the question is, does the extended FMLA apply to companies under 50 employees? Yes, it does. The extended FMLA applies just like the FFCRA to all companies. So just the FMLA, the good old-fashioned FMLA, applies to companies that have over 50 employees and is specifically for the health reasons. The EFMLA, which is part of the Family First Coronavirus Act, applies to all businesses, even those under 50 employees. Can I name the form again for unemployment? It's Form 1921. That's to the refusal to return to work form. Let's see. Okay, an answer to the EIDL question. The EIDL can be deducted from the PPP. In certain circumstances, the forgiveness application asks the information but does not give the circumstances. So yes, it can in certain circumstances, and I will put you back to your accountant for that information. And I think we're coming close to the end. So this is the toolkit that I was talking to you all about. We've offered this to our clients and on the webinars that I've been doing for a flat fee of $350. It includes all of the state orders, the CDC orders, and the OSHA orders, the operations checklist on how to get your business operational again, the employee recall to work, the template letter to send to the employee, an unemployment checklist, and a link to that 1921 form, an employee return to work questionnaire if they've been out of the office or away from your work site for more than 3 days, and a daily employee assessment form, internal unemployment forms for the PPP exclusion, the COVID safety policy, an FFCRA checklist, and the paid sick leave and extended family medical leave policies and forms for the employees to fill out so that the employer gets the tax credit, a sick employee checklist. I know one of the questions in the chat box was about if you have employees that are sick, we have a whole checklist on what an employer should do. a contact trace form and the CDC guidance that came out last week regarding the contact tracing, acknowledgments for employees to sign for policies and training, and a visitor policy and acknowledgement, and a telecommuting policy. All of the documents are in Word and can be customizable to your business. And there's a letter that goes with them that explains how to use them and what each policy and form is for. So if you're interested in that or need more information, you can email me at info@cregerlaw.com. And I think we've gone through, I think I've gotten through all the questions in the chat box. Also, I have on this last page, link in with me, or if you want my blog, my email is at the top of this page. Send me your email if you want to get my blog. I promise I don't overwhelm you. I don't send anything out with any regularity, like every Monday or every Friday. I simply send out blogs that says, hey, small business, this may apply to you. Here's an update on the CDC, here's the regulation, and here's why it's important to you, small business owners. So to the extent that you want to catch that on LinkedIn or be on my blog to get those updates for your small business, shoot me an email. If you want more information or want to talk about the toolkit, there's my number and my email, and I'm happy to continue conversations or schedule consultations to help all of you kind of open your business and get working again.
Thank you. Thank you, Christina. Wow, tons of information. I'm sure you're exhausted by now. And I repeat, I want to make sure everyone understands you. We'll get a link to the actual webinar so that you can review the material that was presented to you. I feel like I've just been staring at a bowl of alphabet soup for an hour and a half. Amazing. As one person just said in the chat box, best seminar I ever attended. Thank you.